Welcome to the NCDWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle, and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 164 of the NCDWI Guy podcast. On today's episode, we look at the criminal trial through the lens of the game of poker. This was a kind of idea that sprung from a conversation that I had with Rob Heroy a couple of episodes back. We kind of carried that over into last week's episode on being default aggressive, which is a skill that Rob picked up as a professional poker player, and he talked about how he had applied that kind of default aggressive attitude towards his practice as a criminal defense lawyer. And so today we're going to look at kind of three other lessons that I think you can extract from the game of poker as applied to your practice as a criminal defense lawyer. I think it's so helpful to look at other places outside the law where these kind of skills and situations are comparable to how we kind of practice in the courtroom. And so looking at these kind of other life examples, I think can be really a powerful way to examine what it is that we are doing when we walk in to represent somebody. So couple of powerful lessons that I think can be applied to your trial prep and to your practice as a criminal defense lawyer. One of the great professional poker players, Doyle Brunson, once said that poker is war. People pretend it is a game. Poker is war. People pretend it is a game. This is something that I think is just such a powerful kind of way of looking again at what we are doing in the criminal defense trial, in our work as criminal defense lawyers, because I think if you don't understand the game that you're playing, you are in a real mess. This is something that we are going to talk about, that I'm planning to talk about at the Game Changer Summit in October, is understanding the game that we are playing. But Brunson understood that, again, this game that seems to be cards and chips and, obviously is this, quote unquote, high stakes game, isn't really a game at all. It is war. And so his mentality, his approach is going to be different. It's just going to be different than somebody that is approaching it as a game. Somebody that is approaching it as a way to spend a couple of hours with some buds is approaching it differently than the professional poker player. A person that is, hitting the blackjack table for 25 minutes on a business trip in Las Vegas is approaching that 25 minutes differently than a person that has been playing the game of blackjack seriously for 5+ years. It's just going to be a different approach. So you have to understand the game that you are playing. So three lessons that I think that we can take away from this are kind of the aspect of bluffing that goes on in a trial of any kind, but we're again going to look at it through the lens of a criminal defense trial. Keeping your cards close to your vest, not showing your hand, and then finally card counting. And so we're going to look at these three areas in the game of poker or blackjack, and then as applied now to the practice of law. So bluffing. When you look at bluffing, I think the first thing to realize is that you've got to understand who is bluffing. Is the in the world of criminal defense, Is the DA bluffing about their case? Are you bluffing? Is the officer bluffing, or law enforcement? Is a victim bluffing about what's happened in a particular situation? I think that recognizing is your client, bluffing. I mean, one of the keys is to figure out who is basically making something out to be more than what it actually is. Mike McDermott, played by Matt Damon in the movie Rounders, said, if you can't spot the sucker in your first half hour at the table, then you are the sucker. I'm going to say that again. If you can't spot the sucker in your first half hour at the table, then you are the sucker. This is something that I think a lot of young lawyers learn relatively quickly, is that you've got to be able to weed out where important information is coming from. Where can information sources be trusted? What is legitimate? Henry Kissinger said that a bluff taken seriously is more useful than a serious threat interpreted as a bluff. A bluff taken seriously is more useful than a serious threat interpreted as a bluff. And I think that what I kind of saw in terms of early practice was there was just way too much trust on my end in various players at the table, so to speak, of a criminal defense trial. One of those was my client. I learned very early on, but it did take some time, and I think that there was times when I put way too much trust into what my client was telling me during the initial consultation. Is that your client on a DWI charge calls in, this is very clearly like a serious situation. They recognize this, but what they are telling you has to be taken with a grain of salt. First of all, your client doesn't understand, when they say something to the effect of, well, I did really well on the standardized field sobriety test, right? I know I did great on those. There's no basis for them to make that analysis. They don't know what the officer is looking for in those tests. They don't know the clues that are the officer is attempting to uncover. The officer a lot of times isn't always being truthful with them about how they're performing, because they just want them to keep on performing the next test. So, at the end of let's say the horizontal gaze nystagmus test, your client might even ask them, your potential client might ask them, hey, how did I do on that? Great. You did exactly what I was wanting you to do during that test. Again, doesn't mean that they actually passed the test. I mean, the officer might find that there was 4 out of 6 clues or 6 out of 6, but they're trying to develop trust with the person they're investigating. So they're continually kind of leading them down this path of, perfect. I just need to do one more test. I need to add, thanks for doing all the field sobriety tests. I just need to double check with a portable breath test to make sure that you're safe to drive. It's always about trying to get more and more information, and the best officers use that to their advantage. They basically are constantly trying to get the person they're investigating's trust into, let's do the next thing. Are you more likely to engage in a second standardized field sobriety test after doing one where the officer says, great, thanks for doing that. I just got a couple more tests to run through with you real quickly. Or, man, you failed that test. I mean, you're clearly impaired. Let's do a couple of more. You're going to be more willing to engage with the officer if you're given that first set of kind of feedback versus the second. So, again, my client, I felt like, was often not understanding what the officer is looking for, could have been grossly impaired at the time of the investigation. And so how much memory is functioning, a lot of people tend to look at these situations through rose-colored glasses. They interpret, something on the ticket with much more import than it should be. The name was misspelled on the ticket, or the wrong court date was issued, whatever it might be. There is just, again, the client's not in the best position to know exactly what is important in charging documents, statements from the police, reports, memory of things going on. There's just, the ability to decipher what is important and what is not is not always there. So again, taking your client's, initial recollections of things during the consultation with too much weight can potentially seriously impair your ability to defend that client, and also create, potentially false expectations either on your own end or on your clients in terms of where the case is going. So that's one place. In terms of the state, I've definitely found that the state is often bluffing about its cases, and I think in part this is like good-natured bluffing, in that the state is so used to, the prosecutor is so used to having, kind of a slam dunk case, that there's not always, a lot of digging into what is this about. Basically, if it's a DWI, they pull, the 5 documents out of a shuck, look at the intox result. It's a 0.13. person was involved in an accident. It's like, okay, well, what would be the issue here? Let's throw this thing down for trial. No conversation with the officer, no conversation with eyewitness that saw the accident, whatever it might be. There's just this trust that, hey, on paper, this is a conviction, or, maybe a brief look over the DWIR. On paper, this is a conviction. Other times, I think the state may know that an officer is not available. And if the defendant is not, or the defense lawyer is not asking, hey, is this officer still with the force? Is this somebody that can, appear in court today? Is your prosecuting witness going to show up? The state is in a position where there's not a requirement to give every piece of evidence that is going to be shown at trial versus what is not. And so if under those circumstances, the defense lawyer comes in and enters a plea of guilty without asking any of those questions or looking into the case, win for the prosecution. Basically just kind of, on the state's end, hey, this looks like client, was, driving at this time, serious accident, blew 0.14, that's where we are. There's not going to be this, generally like kind of forthcoming information that my prosecutionist lives in West Virginia and has told me that he's not coming to court. Like those type of things may very well not come out. So bluffing is a huge play in a trial by all sides. And so bluffing is just such a big part of the game of poker. If you have a bad hand in poker, Texas Hold'em, first cards are dealt, you don't immediately just basically every single time that you get a bad hand say, I'm folding, I've got a 2 of hearts and a 3 of clubs. I'm out. I'm done with this. I'm gonna, just put my cards out there. I'll let everybody at the table know what I have. No, I mean, you might play that hand and see if you can maybe come up with a straight, or you might, play that hand and just kind of use it as an opportunity to show that even if you have bad cards, you can't really be judged in terms of what that particular hand looks like. And certainly if you fold, you may not show your cards, or you likely would not show your cards when you fold. So the only way to call the state's bluff is to basically take it to trial, and you get to see whether or not the state is bluffing. But there are some ways to call the state's bluff pre-trial through thorough investigation. So in the game of poker, you don't get to look at your opponent's, the other player's hands. You don't get to look at their cards. That's not so in a criminal defense trial. You get to, generally speaking, look at the state's case through discovery. So in district court on a DWI, evaluating whether a case should be taken to trial can only happen through thorough investigation, can only happen through getting the DWIR, can only happen through getting the video. There have been so many times that things that I have seen on video or on a DWIR completely change the way that I, view things. I've seen a DWIR come back where my client was stopped for speeding. Ultimately, they blow a .08 on the DWIR. It says no slurred speech, no red glassy eyes. Did well on field sobriety test. Like that wouldn't say did well, but 0 clues on the one leg stand, 0 clues on the walk and turn. I've seen a DWIR with all of those things in it. And so, again, going into things, I may not have very much optimism about, okay, well, was there a valid stop? Was there probable cause to arrest? And a lot of times it is the officer's paperwork that lets you see, is there a legitimate challenge to reasonable suspicion, to probable cause? Is there going to be something that I could bring up? Is the state going to be able to show beyond a reasonable doubt that my client was the one that was driving? Would they be able to survive a motion to dismiss under Kraft or Eldred? All of these things can only really be seen once you've got a more full picture. So you have the ability, generally speaking, to get a chance to look at the other side's hand. And so, use every opportunity to do that. If you have open discovery in your county on district court cases, on DWIs, take advantage of that. I mean, why would you not want to see what the other side's cards look like? You're doing your client a grave disservice if you're not investigating thoroughly your the charge. I mean, literally the difference between being convicted of a DWI and not being convicted rests in a large way on your shoulders of appropriately looking under every rock, uncovering turning over every stone. I mean, that's part of what being a true defense attorney is about, is making sure that the state can prove what it says that it can prove. So do your client a service and actually look into that. If you're not in a place that has open discovery, talk to the officer. The officer comes to court, ask them questions, basically see if you can get a sense of things. And I think the best way to do this, the best way to get discovery, is to kind of humbly go in and ask for it. If you come in demanding, hey, I need a copy of your report right now. My client says that you didn't give them their Miranda warning, some stupid thing, give them their Miranda warnings, or, my client says that you never saw them on scene. If you go in like that, you're going to get, a very kind of like hostile explanation of things. If you go through it and just say, hey, I represent Mr. Jones on this charge. Just trying to kind of figure out what was going on at the time that this happened. Can you tell me, what happened? How'd you stop? What tests were you able to do with my client? Was he polite and cooperative with you? If you kind of set this up as, hey, we're in this like evaluation process, we're just trying to kind of see what's going on. I want to be prepared for, sentencing, all of these ways. If you're going in just kind of asking these open-ended questions, you're going to get a much better read from the officer about the case than if you go in with, kind of like sabers drawn, saying, hey, we're taking this thing to the bitter end, and you better be prepared to tell me what happened. Like, if you go in with this demanding attitude, you're going to get very limited information, if any, from the officer before trial. So you got to do a thorough job in your discovery investigation to call the state's bluff. So often the prosecutor just does not have the time to do an in-depth dive into the 40 DWI cases that are on their docket for the day. It's, the prosecutor is banking on the fact that 80+% of those cases are going to be pled. And so why would the prosecutor read, 35 reports on a DWI investigation that he's never going to have to try, that she's never going to have to try? It doesn't make any sense to put all that time when there's so limited time in district court to get prepared. So they have to approach it from this side of, hey, we're ready to try this thing, and we've got what we need on that. When they haven't even looked at the report, they haven't watched the video. I mean, they have to go in with that kind of like bluffing attitude of, this case is for trial unless you plead. If they start kind of moving back from that, then every defense lawyer around is going to be saying, well, hey, what about my case? What about what about this situation? Why is my charge not getting dismissed or reduced or whatever it might be? So you have to really make sure that you are able. You got to be able to kind of know that, hey, the state is bluffing on a lot of these cases. Again, not so much from a point of undermining this, just from a point of they haven't had the chance to look at the discovery. So getting the discovery will allow you to see the state's cards, so to speak, but not all of them. You have to take cases to trial in order to get a chance of looking at the state's cards fully. You have to. And here's the best example of this on a DWI charge. You can look at a DWIR, and that is a kind of what I call beer glasses officer lens of a case. Everything in that DWIR is generally pointing towards impairment, not pointing towards sobriety. So things that are left off of that DWIR, that weren't noted, person had, if there's no slurred speech noted, then, likely it means the officer didn't hear that, but they don't put in the report, did not identify slurred speech, it did not identify, staggering or problems moving around. They just leave that information off. And again, this is not to fault the officers. They're writing their report with a directive of, I'm investigating an impaired driver, so I'm putting down the clues that lead me to believe that this person is impaired. I charge them with driving while impaired. Why would I point out the places that they were acting, in a sober manner? And I have seen, clues of sobriety indicated in DWIR, so it doesn't mean that stuff's always left out, but most of it is a one-sided telling. You cannot tell from a driving while impaired report if an officer is certified in standardized field sobriety testing, if they know how to give the instructions correctly, if they are identifying the appropriate clues. You just can't tell those type of things from the DWIR. So there have been so many times when I've taken a case to trial and I thought we were dead to rights based on the driving while impaired report. There was no chance of attacking this case through, what reasonable suspicion, or particularly, I would say, through probable cause. And then as the evidence on the stand unfolds, as cross-examination unfolds, I realize this officer has no idea how to do the field sobriety test. This officer is not certified to do the field sobriety test. It basically kind of unveils that this was a witch hunt. And you cannot tell that on the actual DWIR. On the DWIR, it looks like your client shows, slurred speech, staggering around, 6 out of 6 on HGN, 4 out of 8 on walk and turn, 2 out of 4 on the one leg stand, all of these things. And then as you get into the investigation, or as you get into the cross-examination with the officer, you start to realize, again, most of this is just gibberish. There's no ability to really articulate what these clues mean, which ones were identified, if they're ones that are identified by NHTSA as being appropriate clues, or if they're just ones that officers making up. It's just been really kind of eye-opening through the years to have those cases where I've called it for trial and just think, okay, this is going to be a relatively ordinary explanation of what's on the DWIR, and then it really couldn't have been further from that once we start digging into it. So I think that's really an important aspect of the criminal trial process is that the only way really to identify the state bluffing, whether that's through the DA, whether that's through an officer, whether that's through a prosecuting witness, ultimately is to take the case to trial. You can call the bluff in a lot of ways through good and thorough discovery and getting everything that you possibly can have to look at it. But the only way that you really can do it is through taking the case to trial. So point number one, identify who's bluffing at the table. To the best of your ability, identify who is bluffing at the table. And as a criminal defense lawyer, use every tool that you have to call a player's bluff, to call one of the other players at the trial table's bluff. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWI-GUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. Number two, keep your cards close to your vest. Keep your cards close to your vest. You don't always have to explain your defense. This was a humongous learning lesson for me, over the years. Is I kind of have this sense that, where there is a legal problem, I can go in, talk to the DA, explain, here's the issue with the case. Can you reduce or dismiss this charge? And so you have to know who's sitting opposite you. You have to know, what the DA's office is like in the, jurisdiction that you practice in. You have to kind of have some sort of understanding of the specific DA that you're working with on a case, because that may sometimes be a good play. But most of the time early on in practice, if I had a good legal defense, I would go to the DA with the expectation of, okay, maybe I can get this charge dismissed and we won't have to go through trial. Maybe I can get the state to kick this thing and we won't have to waste everybody's time. And, on DWI cases in the jurisdictions that I practice in, it really is just this very heavy default on the state's end of, hey, we're just going to take cases to trial, regardless of what the defense is, legal issues, we're just going to take a case to trial. It doesn't matter if it's a .06, doesn't matter if, there's pretty serious issues with PC. We're just going to take it to trial. If the judge, doesn't find PC, doesn't find the stop was valid, finds your client not guilty, fine. We'll let the judge deal with that. But there's a lot of, I would say, pressure on many DA's offices not to dismiss DWI cases, criminal defense charges. If you've got a prosecuting witness involved in your case, obviously the state is worried about how the prosecuting witness is going to see a dismissal reduction, wants to see if they can get their buy-in with this. So, the officers a lot of times have say in how these cases go. So the DA's hands are somewhat officially tied on DWI cases when it comes to the long form dismissal and being able to kind of adequately explain that. But even beyond that, just the other people in the room that may have some sort of interest in how the case is disposed are going to weigh into that. So, I think early on, if I had a good issue, I would take it to the DA and say, here's what our defense is. Here's my pretrial motion. This is what we're arguing. And, I think that over the years, my position has changed to, make the legal argument vague to non-existent. So basically, put as much out there as is required to be stated. If in district court I have an issue as to PC, I just say we're challenging the probable cause on this front. If I have an issue as to the stop, reasonable suspicion, I don't get into the weeds of, okay, well, here's what was going on, Madam DA, with this anonymous tip that came in, and here, based on this and that case law, this is why I don't think was a good stop. With PC, the officer told me they didn't see XYZ on this, so let's move forward. The more that I gave to the state, it didn't typically result in a dismissal. It typically resulted in the state working harder for the conviction, having a conversation with the officer to get clarity, watching the video, getting a witness that they otherwise may not have requested. So the more that I divulged about what our defense or issue was, the more work that they put into it. So, this is something that I think keeping your cards close to your vest is just such a powerful play. If the state doesn't know what the issue is, and again, this is not to say that, like, on a pretrial motion, DWI implied consent, you're required, if you know about the issue ahead of trial, to make a pretrial motion, give the kind of legal justification for your motion. So again, doesn't mean that you don't follow the requirements in terms of putting these issues out there. But again, you can still do that in a vague way, or, if I have a case going to trial, I just say we're going to trial. I don't say the issue is driving. The issue is, this is a PVA situation. This is a, we're attacking the result of the breath test as not being, valid basis for conviction when looking at all of the other evidence under Nahron Simmons. There's no forecasting of a case going straight to trial. I just don't forecast where the issues are going to be, because then the state doesn't know. The state does not have the ability to kind of see what issues are going to get brought out. So if you have a case that's going to trial, and it's going to trial, maybe your client has an immigration issue, and that you just have to take this case to trial. That if they're convicted, they're going to lose their job. You have to take the case to trial. Maybe just there actually is a great issue that about. You're going to take the case to trial. Don't divulge your reason for taking the case to trial before you enter that plea of not guilty and the evidence starts. Do not forecast where the defense is going to lie. Make the state prove each and every element of the charge, and forecast as little as possible where you are going. Most of the time people want to know where it's going. So if you have a situation like this, most of the time the state is going to ask, well, hey, what's your issue? Like, what, why are we wasting time dealing with this? And so generally a good thing to do is, if you have a situation where you don't want to take the case, or you want to take the case to trial, again, you can be vague in that answer. It's my client's decision. They want to take the case to trial. That's what we're moving. It is what it is. I've looked at the DWIR. I know what it says. But my clients decided to take this case to trial. It's ultimately the client's decision based on a conversation. Hopefully they're listening to their attorney, but it's ultimately the client's decision to take a case to trial or to enter a plea. So if they're taking the case to trial, you can always just put that back on your client when you're talking to the DA and say, hey, my client's decided that, they are not going to enter a guilty plea. We're going to throw it up there for the judge. Give as little information as possible about your defense. If the state is not prepared, you can't prep a witness that's already on the stand. You can't, do all of the legal research on an issue that you don't know about. So this is one of the few areas where the defense has an advantage, and that advantage is preparation. That's one of the key advantages, maybe almost like exclusive advantage that a criminal defendant has in a case in district court is that the state is just slammed with cases, slammed with people to talk to. The DA slammed with officers, prosecuting witnesses, defense lawyers responsible for, having sidebars with the judge on. I mean, they're just constantly slammed and bombarded. And so they have to be ready to try a case in 20 minutes, the 15 minutes of prep, boom, we're ready to go. That's not true of every prosecutor, but that's just the way that it is most of the time. And so that is an advantage for the defendant whose attorney has had hours to prep for this case, days to prep for this case, months to prep for this case. I mean, there's definitely an advantage in preparation on the defense end of things. So don't give up that advantage by allowing the state to get prepared on the issues that are going to come out. Again, with the caveat that if you're required to make to explain your basis for suppression ahead of, an implied consent offense, obviously don't forfeit that based on, keeping your cards close to the vest. But number two, don't divulge things that you don't have to divulge on a case that you expect is going to go to trial. Keep your cards close to your vest. And then finally, number three, card counting. Okay. If the best blackjack, players know how to card count. They have this sense of what is the competitive advantage. And so card counting in blackjack is based on this idea of expected value on future hands, on future cards that are going to be laid down over time. How is the next hand likely going to play out? This is all based on probability, right? Nobody can still forecast exactly which cards are going to be played next, but somebody that is a top quality card counter can evaluate each hand based on the expectation of what the last hand came back at. So, this is a quote from a book called 21st Century Card Counter. When you begin to understand expected value, EV, when you begin to understand EV, everything in the casino changes. It's not unlike becoming Neo in the Matrix. While everyone else is living a lie in the casino, believing in luck and epiphania, you suddenly begin to see the mathematical expectation behind every decision. Card counting is a massive advantage. Again, this is not cheating. This is not illegal. I was watching some sort of a documentary recently on blackjack players, and when casinos get the sense that somebody is card counting, they will quickly ask them to leave the casino. It's not because that card counter is doing anything illegal. It's because the casino is going to lose money if that player continues to play in the casino. So when somebody is winning in a casino based on card counting, that player is going to get booted. So this is all about probability. Again, this is not the same as seeing the other player's hand, like you get to see when you're calling a bluff by actually viewing the other player's cards, through discovery, through cross-examination during a trial. This is based on probability. So again, if you have an old case that is 5 or 10 years removed, card counting comes into play on this front. Is the question is the officer available? Well, you can do some research. You can call the police department that the officer is with and say, hey, can I speak to this particular officer? You can talk with the officer in court. Hey, do you remember what was happening with this case? Figure out if there's independent recollection of the events. You have the ability to to kind of forecast what a likely outcome is going to be. This requires that you are a attorney that has been coming, has been playing repeated hands. So this is not so much about playing one round. This is about, kind of your chances of increasing your likelihood of success over multiple hands, over kind of elongating the game. In the criminal defense world, multiple trials. How are these legal arguments landing on judges in the jurisdiction that I practice in? We have near statewide practice at this point. I think we practice in about 65, 70 counties across the state. And, legal defenses on DWI cases that work in one area don't work in another. I mean, that's just the way that it is. Legal issues that work on one side of the state don't work in another part of the state. And so this is something that you have to be able to see, what issues are landing, what defenses are going to work with your particular DA's office, with your particular jurisdiction that you're practicing in, because it's very dependent on your particular part of the state. So this is where, in a comparison to blackjack, playing the game repeatedly, playing repeated hands, taking repeated cases to trial, you're going to see what things are landing in your particular jurisdiction. And so, this is something that is I would say, compared to playing the long game, just because, you've played one hand, just because you've taken one case to trial does not make you, a experienced, great, high profile defense lawyer. You're a novice, you're a beginner. The first 50 trials that you have, there's going to be a lot of ugliness that is on your end when it comes to taking cases to trial, but you're learning, you're constantly refining, you're constantly able to see, okay, well, what is the next question that is likely to be asked by the defense lawyer? What is the next, question that the judge is going to likely ask me about this particular legal argument? What is the next thing that I should be doing when the state seeks to introduce this particular type of evidence? You get good at mastering that ability to kind of use past experience to predict what the next round is going to look like. And so that is such a huge advantage. And the only way that you can do that is by playing the game repeatedly. So again, this is all based on expected value. And again, this quote, when you begin to understand expected value, everything in the casino changes. It's not unlike becoming Neo in the Matrix. While everyone else is living a lie in the casino, believing in luck and paraphernalia, you suddenly begin to see the mathematical expectation behind every decision. And when you watch a great criminal defense attorney, when you watch a great DWI defense lawyer in the courtroom, it is somewhat like watching Neo in the Matrix, like just the understanding of the way that evidence is coming out and the way that the legal argument intertwines all of the various facts from this particular charge into North Carolina case law is just somewhat beautiful. And it just is something that is so wild to see, and to the attorney that's doing it, because of the amount of times that they've done it in practice and experience, it has become a science as much as it is an art. I think from the outside view, it looks almost completely like art. Like there's just this kind of unbelievable, masterfulness of this defense lawyer. But in reality, it is as much a mathematical expectation as it is art. That's really where like science and art of trying a case comes together. So again, trying to pull life lessons from other areas outside the law to give us competitive advantage in the courtroom. I think there is a ton of great trial values that can be gleaned from the game of poker. And so hopefully this has been helpful. I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.